cause number PD 061623, Larry Gene Strickland II versus the State of Texas.
Good morning, and may it please the court. I'm John Messinger, Assistant State Prosecuting Attorney on this case out of Hood County. Article 4208 says that a trial court has discretion to stack a new sentence on top of an old sentence. The statute doesn't say anything about the specificity that has to be in the judgment. It doesn't say that there's any fact-finding that needs to be done. And in fact, this court has made it clear that there is no fact-finding, that it's entirely a normative decision, and that a lawful cumulation order is unassailable on appeal. Yet this court sanctions the assailing of multiple stacking orders for various reasons. One of them is for lack of an unspecified level of specificity in the judgment, and also for having inadequate record proof to show that the defendant does in fact have a prior conviction. This is not a new issue. This court's granted review of this issue in 2000 and again in 2006, and has been flirting with the idea of having a remedy, because there is no remedy at this point other than striking the order. The court's been flirting with a remedy for 25 years. And I think this is the time to take the opportunity and clean this up and go back to what the statute requires.
Do we have to overrule any prior decisions of our case? I mean, do we have to overrule any prior decisions in order to agree with your position?
Yes, many of them. Depending on how you interpret the statute, it's been written as a discretionary statute since 1919. It was non-discretionary going back to 1879. So either way, there's a lot of water under the bridge. The problem is if you want to call it a prophylaxis, what we've built onto the statute isn't dictated by the statute. And it's been at odds with how this court has been addressing similar issues and things like preservation and error classification more broadly since the mid-90s. So it's become unsustainable if it was a good idea at some point in the past.
When you characterize what we have to overrule as many opinions, it kind of makes it hard to figure out what specific language in any specific opinion is in conflict with what the statute would otherwise require. Can you be more specific about some language that maybe has appeared more than once that is the problematic language?
Sure. Well, the overarching body of law that says that the cumulation order, which is in modern parlance that portion of the judgment that says that it's going to be, the sentences are going to be served either concurrently or consecutively. That goes back to the late 1800s, that there has to be specific language in there that says what is the prior conviction you're stacking it upon. And there's a preferred list of 5 descriptors of what the prior judgment is. It's exactly what you think it would be: the county, the court, the offense, the cause number, the date. And that would be the preferred way of doing things.
Hasn't the court described them as recommended, though, in the past? I mean, if they're only recommended, then...
This court has never, if it did at the beginning, it has been a long time since the court has required all 5 of those identifiers. What they require is some combination of identifiers or some exception, like both convictions came out of the same court, and that's on the record, or a judicial notice exception. But some combination of information on the judgment that would allow, and the current rationalization is allow TDCJ to look at the face of the judgment and understand the order that sentences are to be served. And that's something that the court has been consistent with. Again, the rationale over 100 years ago was the form books say to do it, and it's a preferred practice. Middle of last century, the rationalization was we need TDCJ to know what's going on, and that's been one that's been cited repeatedly since then.
To the degree that it may be insufficient for TDCJ, does the defendant have standing to even raise an argument that TDCJ can't understand this, or would we want to hear that from TDCJ?
If you heard it from TDCJ, I don't know why you would take the complaint. So the short version is, I don't know what right a defendant has to have a judgment that can be easily read by a third party. And when it comes down to the propriety of the stacking itself, whether or not the stacking order violates 303A, this court has said that's an individual right. It's not an absolute systemic right. And that's why I would go back to just basically how we've been looking at preservation since at least Marin in '93. What is the right we're talking about, and why shouldn't you have to say something about it at trial? Certainly, I think the defendant should have knowledge of the order in which his convictions are going to be served. And we have an oral pronouncement rule which gives them the opportunity to object, and we have to have an oral pronouncement rule because if you walk out the door without the judge saying anything about your sentence not starting today, it starts today. And you can't go back and stack an already commenced sentence on an older sentence. So we have oral pronouncement, and the defendant has every opportunity to say something at a time when it would do use to the court. Right now we have a windfall scenario. Under the current state of the law, you can listen to the judge make an announcement. You can know exactly what the judge is talking about. Surely the defendant knows he's currently in prison. The judge knows he's been benched back for the new trial. Everybody there knows he's serving at least one sentence. And if you think you don't hear the magic words from the judge, you can just keep your mouth shut and wait till appeal, and you can raise it on appeal. And at that point, the remedy isn't to send it back to the judge to make a more specific pronouncement or put more evidence in the judgment. You just strike the cumulation order. So all of the authority that the legislature has given the judge to stack, it goes out the window without an opportunity to fix it.
What would happen in a situation where, say, a trial court was not strictly as clear about the sentence he was imposing? For example, let's say second-degree felony conviction, the judge says, I'm sentencing you to years in the Texas Department of Criminal Justice. And the judgment reflects that as well, but doesn't contain a number. What would our remedy be under that situation?
I mean, if the oral pronouncement didn't have a term of years, you would have...
Said years, I mean, said...
So presumably some time, right. So if he pronounces that you will be in there for some amount of time, and there isn't an amount of time, it needs to be sent back because that's not a proper sentence. And you might even send it back for resentencing for an entire hearing. But at the very least, you would say, clearly you had a number in mind and maybe you forgot to say it. And that's what would happen. We would allow the judge the opportunity to fix it because it's clear you wanted jail time or prison time. And we just don't know. And this is what happens with restitution. I mean, what this court's body of law on restitution puts a very fine point on this. Findings of fact in the record, well, not findings, but supporting evidence in the record to support the restitution amount is required by statute. And this court has held that restitution is, in fact, a punishment issue, whereas accumulation is just a relationship between two sentences. So restitution is a punishment issue. Evidence is required by statute, and this court requires the defendant to object if they see a problem with how restitution is being ordered. And if they object and they're correct about the lack of proof to support it, the remedy is not to strike it. The remedy is to send it back to take more evidence. And that's what should be happening here. At the very least, a judge should be given the opportunity to clarify what he or she meant.
Is accumulation order a part of the sentence, or is it something different?
It's something different. If you run through 4201, there's the offense of conviction. I think there are 34 things just in 4201A that should be in the judgment. One of them is the sentence, the term of years. Another one is the order required by 4208 to establish the order that sentences are served. So it's not part of the sentence, but it is how these sentences are to be served, which overlaps with the definition of sentence in 4202, but clearly in the context of 4201, there's the term of years, and then there's how that term of years relates to a prior term of years.
So your remedy ultimately would be to ship it back for clarification? Or are you suggesting a judgment no proton?
Well, one, I think this record is clear enough. And I think that when it's clear that the judge wants to stack and the judge is giving a cause number and a prior offense of conviction that I think appellant should be aware that he's currently serving, I think appellant should have objected if he wanted more specificity. If this court is not going to impose a preservation requirement like it does with restitution, and you don't think that the judge's reference is clear enough for somebody at TDCJ to figure it out, then the remedy would either be to send it back. I would say send it back for clarification. I mean, again, there are two separate errors that this court has been running. For the longest time, the problem was just the specificity of the order. And it's a hyper-technical requirement. That's kind of fallen by the wayside. And so what's happened in the last 40 years is the shift has been, well, there isn't enough record evidence. And for a while there, the court hung its hat on lack of authority. Well, if you don't prove that there's a prior sentence, the judge has no authority. But Barrow and Beatty make it clear that authority comes from the statute, not from some triggering fact. So then in Moore, the court shifted to, well, it's a sufficiency thing, and sufficiency doesn't need to be preserved. But in either event, if there isn't enough evidence in the record, you can send like restitution. Just say, okay, which prior conviction are you talking about? And if the problem is the order itself, well, the judge has made it clear it's this cause number, this offense. That judge presumably can get the information. He had something in mind. He can fill out the rest of the order, and then everybody knows what's going on. I mean, that's the problem. An appellant did not object to having any notice, and the argument still isn't, gosh, I don't know in what order my sentences are being served. The entire complaint is, there's a mechanism in appellate law where I can have my cumulation order struck because there's some information missing, not enough to meet some threshold. We don't need all the elements, but in this case, we don't think there's enough elements, so it's a windfall, and that's what they're going for here. So
We talked about, or you talked about the failure to object. Is the trial court, does the trial court have discretion to do this without a request for stacking?
yes, and that's what's interesting about this case. The judge has complete discretion to do whatever he or she wants to do, with or without a request. Most of the cases involve a request. And so a lot of the cases, like the seminal case, 1987's Turner, talks about how weird it is to ask the state or to ask the defendant to have a burden when it's the state that's moving for cumulation. And those cases, it's just a coincidence that the state was moving. And generally, when a party moves for something, they have some sort of burden. But the fact of the matter is the judge could have done it just because it was Wednesday. And so if you want to object to the cumulation, that's the time to do it. And I should point out that there was an objection in this case, but the objection was the state didn't request it. There was no objection to, I don't have a prior conviction, or I have multiple prior convictions. Which one is it, because I need more clarity? It was they didn't ask for it, you shouldn't be able to do it, and that's not a valid objection. And they came back in a motion for new trial, and in the motion for new trial, the complaint was, look, I had a couple technical violations, and you maxed me out with 10 to do and then stacked it, and that doesn't seem right. It also wasn't an objection to some sort of underlying deficiency in notice, if such an interest exists.
Do you think that if a trial judge, we talked about the fact that a sentence begins to run whenever it's pronounced in open court. Do you think that's true even when in the same moment, the trial judge signals that he wants this sentence to be stacked upon some other sentence so that it's clear to everybody in the room that it's not to take effect immediately, but only upon the expiration of some other judgment, whatever that one might be?
That's right. The judge is making it clear that you're not starting this new sentence today. And that would be the point, if you're confused as to when the new sentence starts, is to say something. Because I don't think anybody has a greater interest in knowing how much time he's serving than the defendant. And if he's confused, that would be the time, and that's what we've done here. Preservation, broadly speaking, is talked of in terms of a judge protecting procedure, and it also protects the system. The legislature, a long time ago, went to lengths to say, first off, if you convict, the first version of the statute was you've convicted 2 offenses in the same term of court, stacking's mandatory. And then in 1919, they made it discretionary, but they put in no limitations on it. And so it's up to the judges, the elected judges in their district. And when a judge exercises their authority, and according to this court, it's lawful authority because it is authorized by statute, then there should be no other common law built onto it that thwarts that authority. And if the policy rationale behind it is we would like the judgments to be written better, then remand to have the judgment touched up. If there's not enough evidence in the record for the court to modify it, then send it back and say, look, this is clearly what you were going for. And as long as the judge can build out the prior conviction that he believed existed and is at least partially reflected in the judgment, then we don't have a problem. If there are no other questions, I'll sit down.
Thank you, counsel.
Thank you.
May it please the court, my name is Jeff Shear and I'm here with Mark Bennett today on behalf of Mr. Strickland. I will be splitting 10 minutes of my time with Mr. Bennett, and thus I may defer a question or two to him from the panel, just so the panel is aware. This case can be described with one word, and that word is breathtaking. I used to think of breathtaking in a positive light for major events in my life, such as the birth of my children, or when I passed the bar exam, or when my wife agreed to marry me. But here, I view it in a frightening light, which is someone can be stacked with an alleged sentence using nothing more than a cause number. The court below, in this case, got it correct with over a century's worth of precedent where it reformed an improper and unlawful cumulation order into a concurrent sentence. And the state has not met its burden to justify overruling over a century's worth of precedent by demonstrating that it's manifestly absurd or unjust. The state says this entire scheme of law is unworkable, but it doesn't provide any data to justify its position.
Can you point to some specific language in some specific opinion that would need to be overruled in order for the court to go with the state's argument here? Because, I've looked through your briefs and, I'm trying to figure it out, so help me out there.
Well, I think one of the major ones, Judge, I believe it was Ex parte Carter, said that this type of error is a Category 2 Marin right and it's not waivable. So I think that's probably one of the biggest.
So what specific language, though? Because, language can mean one thing when it's paraphrased, and I'm curious about the quotes. I don't know. It could be that it supports your place, but I'm trying to figure out what specific language.
Yes, sir. Well, if you're asking me for a quote, Judge, I might have to hunt through my brief.
No, I mean, that's my, I'm searching through the brief, so I'm looking for some specific language that would suggest that, if a accumulation order is insufficient, the Court of Appeals is required to delete that from the judgment, and it cannot be sent back for clarification. That's what I'm looking for. And, maybe it's there. I'm having a difficult time finding it myself.
Judge, I might need to process that for a second.
Okay. I don't want to disrupt your whole argument, so carry on. That's one question that I have in studying the briefs in the case.
To pivot off your question, though, Judge, one of the main things that the state brought up is that the case law, they're arguing that the case law implies improper stacking orders are unassailable on appeal. Well, that's not true. The thing that's not assailable on appeal is when a case is properly stacked. And so here, what we argued below was that there was an abuse of discretion. The judge's authority under 42A was never triggered to stack. And that is assailable on appeal because there has to be facts in the record to support any judicial decision or order. Due process requires judicial action to be supported by some sort of facts or evidence. And I believe that's the, we cite a Supreme Court case about that, and we also cite several cases about that in our brief.
Why? I'm also curious about this. So the defendant is standing, in my experience, being in courtrooms, when the defendant is sentenced, he's standing right in front of the bench. And so he's hearing the judge say, in this case, for example, I'm sentencing you to this, I'm stacking this sentence upon the sentence in this cause number. And by the way, if that's not enough information for you, it's the one where you were convicted of this other specific crime. And the defendant says nothing, but the defendant, surely he's on notice at that point that the sentence in this case is not beginning today, right? He's being told by the judge that it's only going to start whenever some other sentence is over. And so wouldn't it behoove the defendant, if he was curious to know about which, if he's not satisfied that he knows which conviction it's being stacked on, to say, well, Judge, which one is that again? I don't know that you're having specified that one crime, and given that cause number is enough for me to digest, maybe I've got a whole stack convictions, but, I mean, how, shouldn't he have to say something at that point? Which one are you talking about, Judge? I mean, and also I'm sorry to go on and on like this, because I just have a lot of questions. I really want the answers. Why is it that he's not on notice, at least, that the sentence isn't starting today as it normally would when it's pronounced in open court?
Well, Judge, Ex parte Hernandez specifically stated that improper accumulation orders are automatically concurrent.
Ex parte Hernandez. Okay, well, maybe that's the case I'm looking for. I have to look at that.
And that's 758 Southwest 2nd 594, I believe. And so, in that sense, the appeal and reformation remedy is really a formality. And I believe it's page 54 of the court's record, even the judgment itself in this case contradicts itself. It says the sentence starts today, if the court was to look at the judgment itself. And then it also has the little section where it says the cause number that it's supposedly being stacked with. But also, what's interesting is it's difficult to create or to object to something when you don't have all the information. So the verbal pronouncement, as we know, typically controls in a criminal case. And so when the verbal pronouncement itself is improper and it's supposed to be automatically be a concurrent sentence, at that point, there's not really much to object to. But also you require the full record to identify what evidentiary or factual issues you're going to appeal under, which in this case, it took some time to get the written judgment in the record. For example, I believe that the accused himself wasn't even thumbprinted on the judgment until 6 or 7 days later. And so the state seeks to analogize this scheme to a remedy associated with restitution, and that's not really proper either, because that statutory scheme imposes burdens, whereas this one does not. There's a burden on each party under the restitution scheme to present evidence, whereas there's no burden for the defendant to do anything. I would say imposing a burden would violate his right to remain silent.
But we do impose burdens on defendants to object when they see an error happening. I mean, that's not foreign to the system. I mean, I grant you, you don't have a burden. No defendant has a burden to show that he's innocent of the crime or that he's not guilty or that, the state has all that burden. But there is a burden to object when something seems not right that's going on in front of the court that could cause detriment to the defendant. Let's say the admission of evidence or a sentence that's illegal, for example. I suppose you wouldn't have a burden there. That's no burden. But there are other situations in which the defendant would need to object, correct?
There might be some, Judge, but I think in this case, because it's been tied to a Category 2 Marin right that requires an express waiver, that would require some deep constitutional revisiting of the case law.
And that's Ex parte Hernandez, correct?
That case is Ex parte Carter, Judge, but it's also tied to McJunkins. I don't have the reporter citation with me on that one. And there's also issues here of reversible error. A lot of times objections tied to reversible error, and the court has repeatedly said this is not reversible error. It's just error that's corrected on appeal by supplementing the accumulation order with other information in the record or striking it. And so, with that, the state seeks to supplement evidentiary shortfalls by utilizing software such as TAMES. That's one of the big arguments they make. And TAMES is a system that's subject to human error, tampering. We've seen what happens when governments are hacked and their software goes down or has problems. And we're also in the age of AI. AI is kind of scary. AI creates fake documents, it creates fake video, audio, photo, and we sanction lawyers for using AI to improperly write their briefs. And so I think that's a dangerous road to go down. I think all this precedent, it opens the door to remand for evidentiary things where the rules don't allow it, and I see I'm out of time.
Thank you,
May it please the court. Good morning. I'm Mark Bennett. Judge Yeary, what is your understanding of the remedy that the state is of what the state's asking for? Because you said clarification. It appears to me that in the state's PDR they suggested that remand for clarification is the remedy, but in their brief they appear to have abandoned that and said that a non-protunct judgment is obviously the best way to go. It's obviously not the best way to go, because a non-protunct judgment is to correct not a judicial error where the judge orders something with no evidence, but rather a clerical error where the judge orders something and then the clerk writes a judgment that says something different. This is not a clerical error. This is a judicial error. And so the remedy that the state proposes, which in its brief, not perhaps in its petition, but in its brief, which is non-protunct, is simply inappropriate. This court, sorry?
I'm sorry, is this part of a sentence? Is this something
No.
that, okay.
No. And this court can no more, well, let me say that if the trial court could enter a non-protunct order because the evidence supported it and the judge said the right thing but the clerk said the wrong thing, then this court could certainly reform the judgment. And I think we've seen cases, I think they're briefed here, in which this court or other courts of appeals have reformed stacking orders because the judge said one thing in court, which is the operative fact, what the judge said in court, but then the written judgment said something different. So
The proper remedy then, according to you, is what?
the proper remedy is to strike the cumulation order, and that is Ex parte Hernandez. It's at page 50, I think 53 of our brief. And I was thinking about this yesterday and thinking, well, why, Mark? Why? I mean, these judges are going to ask you, why is this the right rule? And I thought about law and economics, and I thought about how the rule that we're defending here is that an order, not just a cumulation order, but any order, has to be specific enough that people understand it just from the face of the order, and they don't have to go to Thames to figure out what the order intended. Well, why is that? Because an order that is not that specific is inefficient. It's a drag on society. It causes problems. And do we know what the specific problems are? No, we don't know what the specific problems are. It's a magic spell. And if the spell is not written right, what goes wrong? We don't necessarily know what goes wrong with the magic spell. But under the law and economics evaluation of this, there's this inefficiency, and somebody has to be incentivized to fix the inefficiency.
Well, did you hear I had a hypothetical earlier where a judge pronounced his sentence on second-degree felony and he says years in the TDCJ. We would send that back, wouldn't we, to redo it?
I think that's an illegal sentence. I think it would be reversed. I think it would be remanded for a new punishment hearing.
I mean, is it illegal or is it just deficient and vague? Because it says years. I mean, it could be that it's legal if it only meant 2 years or if he only meant 5 years, but...
I think it's an illegal sentence.
Okay.
Even if it's not an illegal sentence, however, I think the remedy there is to send it back for a new punishment hearing, which is clearly not the remedy in this case. Where nobody's...
Speaking of inefficiency, to do the whole hearing over again? Because...
in that case, right, where the judge has... And this is the rules which came from Wilson's form book. And I talk about that in my brief, and it's really enjoyable for me because I got to dig down into that Texas legal history. But the rule on what the order should contain, which is based on the common law rule that orders have to be specific in order to be enforceable, which we see in other areas, such as injunctions and orders enforceable by contempt. But I just lost my place. Anyway, but the rules from Wilson's form book that everything has to be identified in the judgment has been the rule for 135 years explicitly. And so judges should know this.
It's in the statute.
Trial court judges should know this. What?
It's in the statute that you're supposed to put that in there.
It's not in the statute, but the courts have been talking about this for 135 years, and trial courts should know it, and prosecutors should know it. And if a judge says something that doesn't follow what everybody ought to know the order has to say, then there are two people in the courtroom who have an interest in actually pointing it out. The prosecutor could say, Judge, we're going to need you to take judicial notice of the judgment. Okay, I propose to take judicial notice of the judgment. We have a procedure for this. Defense, do you object to me taking judicial notice of this judgment? Yeah, Judge, we object. Why do you object? I don't know. We object. Okay, I'm going to take judicial notice of the judgment, and I'm going to stack this sentence atop that judgment. The state has a motivation to do this at that time. The court, the trial court, should know this and should have the motivation to do it at that time. But under the law and economics analysis, the only way that we eliminate this inefficiency is to allow the defendant to challenge the judgment and to strike that contempt order, strike that cumulation order if the cumulation order is invalid, which is how the law has evolved. Yes.
Specifically, what is it that the trial judge left out that makes this an inappropriate sentence?
What would have been
What element?
What would have been, any of several other things. The judge could have said, I recognize you as the person who I sentenced in this other case, and I'm going to stack this judgment atop that one. That would probably be good enough. If the judge had said the county of the other judgment, then that probably would have been good enough. Because somebody then looking at the judgment could tell, okay, it's this case number in this county, and in most counties there are not separate, you're not going to have two case numbers from separate courts that are the same case number.
Why does he have to say, I recognize you as a defendant I previously sentenced? Because he may have forgotten it, certainly the defendant would not have forgotten it.
Well, because the record, one of these common law principles that we're defending is that orders have to be supported by evidence. And my brother from the state says, well, a lawful order is unassailable. Well, lawful is not a description of every order. An order that is lawful is unassailable, but you can't determine whether the order is lawful or not without assailing it, without appealing it. So what got left out is enough, what needs to be done for the sake of, and it's been this way forever, and what we're proposing is simply continuing to follow the law as it was when the Texas Constitution was written, which is that orders have to be specific. Why do they have to be specific? Well, I mean, the defendant is the one who gets to appeal it. The defendant is given the remedy, but the underlying reason for that is that nonspecific orders are inefficient.
So could we go back to Judge Richardson's question about what more needed to be in?
The county would have done it, because then if you had the county and the cause number, that would have been enough. The judge taking judicial notice that this was the same defendant probably would have done it. I recognize that you were the person that I sentenced in cause number XYZ, and I'm stacking this atop that.
Did he not say something like, and I can't quote it, but the one in which you were convicted of this kind of crime?
Yes.
He said child pornography.
Okay.
So yes, and it's not enough. If you can look at it and you can say, well, it is not unimaginable that there are two of these sets of facts that are declared in the order and in the judgment that are different people, then it's not sufficient.
But he gave a cause number too.
Right, so yes, and these cause numbers are recycled. Lots of different counties, I think 9 different counties I listed in our brief use the same sort of cause numbers. So just the cause number and just the sort of case and just the name, cause number, sort of case could very well be repeated in different counties and could be different people. And unfortunately, TDCJ, if we put the burden on them to cure the inefficiency, which itself is an inefficiency, requiring somebody outside the judgment to decide how the judgment should be interpreted, could conceivably get it wrong.
So 9 different counties would have a guy with the same name and the same cause number with the same offense?
Not necessarily, but it's conceivable that there could be 2 people in 2 of these counties who have the same cause number, the same name, and the same offense. And so the specificity would require that not be a possibility, and that it be shown from the face of the document, from the order, that it not be a possibility. And here, it is a possibility. Here, how could the judge have prevented that from being a possibility? Well, if this is the case that the state has found in Thames, then the judge could have said, in this court, in this county, and that would have solved the problem. The state could have made this objection at the time, could have fixed the problem, and we wouldn't be here. We pray that this court affirm the judgment of the Court of Appeals maintain stare decisis in Texas and keep the rules as the common law requires them to be. Thank you.
counsel.
May it please the court. I don't know how many convictions for possession of child pornography with that cause number appellant has, but if it's more than one, that would have been the time to say something about it, and we could have gotten this straightened out.
Let me ask you about that. Let's assume there were a couple of convictions. One had a shorter sentence, one had a longer sentence. You may have addressed this, I don't remember. And in the trial court, the defendant thinks, oh, he's stacking it on the shorter sentence, but the judge really means to stack it on the longer sentence. How does he get relief?
That would be in a writ. And Ex parte San Miguel from 1998 covers this, that the real interest that a defendant has is not having an order that's specific enough or having evidence at the hearing that would support it if pushed on direct appeal. It's not being incarcerated longer than you're supposed to be. So your problem doesn't come about until you think you've finished a sentence and you're supposed to be released, and you haven't been released.
Okay, then what does he do?
And then what San Miguel says is you file the writ and you say, hey, I have this order, and this order is wrong, it was improperly filed, I should be released because I'm not properly stacked here. And the burden's on him, partially because of the procedural setup of a writ, to make the record clear that that's not what was supposed to happen. This sentence was supposed to have been served concurrently. In that case, it was, he'd think that the order was void entirely. In your hypothetical, it would be, I should have started serving this sentence 8 years ago instead of today, so I should only have 2 years left. So really, he can't complain until the 2-year point where he thinks he should be released, and then he's being illegally incarcerated. Does that answer your question?
Yes, thank you.
A lot of the conversation we've had,
Raise a latches issue if you wait too long.
well, he doesn't realize that he's going to be incarcerated longer until that date. And this is the fix that they have themselves in. If this is something that you can raise for the first time on appeal and it's statutory, you shouldn't be raising it in a writ anyway. So you couldn't be complaining about some impropriety until you're illegally incarcerated. So I don't think this is a scenario where latches is going to create a problem. You may have other burdens before that time or other problems with raising it with cognizability. One of the things opposing counsel was talking about is the lawfulness of it. And in this context, lawful is a term of art. Lawful means not in violation of the authorizing statute. Authority comes from the authorizing statute. So all the cases he's referring to, Carter, going back through LaPorte, going back to McJunkins, which is 954 Southwest 2nd 39, if you're interested, they're talking about clear violations of Section 303, where you have a defendant who's tried for multiple offenses arising out of a single criminal episode. He's tried in a single criminal action. His offenses aren't on the list of things that you can stack, notwithstanding consolidation, and the judge does it anyway. This court has said that is a Category 2 right. You can do that if you want to, and as part of a plea, that may be necessary to do, and one of the I think Carter may be a waiver case, but that's the context we're talking about, where it's very clear on the face of it that 303 was violated and no judge has any authority to stack these sentences. That's not what we have here, and Barrow and Beattie make it clear that when you have a case that has one of these problems, there could be more evidence in the record to prove up the prior conviction. The judgment could be more specific, that you don't have a lawful problem, you have a more traditional problem that this court has been doing for years. I don't know that I've read a case that says you have to strike the order. I just know that that's what's been done forever. So,
You're familiar with Chesterton's fence. I think it might have been referenced in one of the briefs.
yes.
If we take down a fence and you don't know why it's there and it was there to keep the cows in, then all the cows might come out. Is there do you foresee any kind of disruption to the system that might occur if we were to
I think
follow your recommendation?
Your analogy is an apt one. Stacking is designed to keep the cows in. In this case, it's designed to keep multiple felons, in this case, in. And there's a stacking order. Opposing counsel talked about there being a drag on society if we're not clarifying orders, if we're not striking these orders. The drag on society is when somebody's supposed to be in prison for another 10 years and he's walking around with the rest of us. And that's the burden.
Let me ask you a question. Mr. Bennett said he asked himself last night, I think, why should we strike this improper accumulation order? So I asked myself the same thing. And my first thought, and you tell me if you agree with this, is that stacking orders can have pretty severe consequences to the defendant. Isn't that correct?
That's the point.
And those severe consequences, you know, could be adding 20 years to somebody's sentence.
99 years, sure.
Time he's gonna be in jail. Well, I think because of the severe consequences involved, a trial judge should actually know something about another case before he stacks this case on top of it. And this stacking, what the judge said made me think he didn't know anything. He wasn't even sure there was another case. And that's why we should create a law where it's much more specific. The judge needs to show that at least he knows something about a case that he's stacking another case on top of.
Well, I'll disagree with your premise and your rationale. At no point should this court be creating a law that creates better policy than they think the legislature has set in place. And I think Judge Bufkin made it clear, you have a prior conviction for child pornography. He was guessing at the cause number from memory. He was correct about it. So I don't think the record fairly shows a judge who's just flippantly saying, hey, if you're already in prison, and I have no idea, after all, I'd be the one who would have signed the order bringing you back for trial, but if you're in prison for something, let's just stack it. This wasn't a flippant decision. This was somebody who gave the defendant enough opportunity to say, I've properly served that, or I have multiple sentences, and could you please make this more clear? But trying to impose a law that's not required by law is just not something this court's able to do.
Okay, thank you.
Thank you.
Thank you, counsel. The case is submitted. Calling up cause number PD 056-423, William Solomon Lewis versus the state of Texas.